All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. This is the time set for oral argument in 1 CACV 160535, Yuma County versus Valenzuela. Counsel, you'll each have 20 minutes for argument. Appellant may reserve a portion of that time for rebuttal. If you wish to do so, sir, you'll need to keep track of the time at the podium clock. Out of respect for counsel and the court, I ask that those in attendance, please make sure your cell phones are off or on vibrate. Counsel, we have read the briefs. We've conferenced the case just this morning, and we encourage you to keep that in mind as you present your argument. These proceedings will be recorded. They'll be posted to YouTube. So before you begin your argument, please state your name and the party you represent. With that, we will start with counsel for appellant. Mr. Feely, go ahead.
May it please the court, I'm Ed Feely, Deputy Yuma County Attorney. I'm representing the zoning inspector in Yuma County. Your Honors, this case requires an interpretation of ARS 11321E, whether or not that provision is broad enough that it's going to allow Mr. and Mrs. Valenzuela, who purchased a piece of property with an existing building without the required permits, whether or not they can maintain that without obtaining the permits.
Is there an allegation that there's something unsafe about the buildings?
The building was not.
It's not permitted. I understand that.
Was not permitted.
But is there an allegation that it would otherwise violate some type of code provision that would make it unsafe, or that it doesn't satisfy like offset restrictions or some other? Is there some other code that it violates?
It violates the zoning ordinance because the zoning ordinance requires somebody who constructs or maintains a structure to have obtained the required building code permits. Right,
but isn't the ordinance says it's unlawful to perform any work without a permit, right?
It also says the statutory provision and the ordinance also indicate that you can't maintain.
What language are you relying on that says you can't maintain?
Well, Arizona Revised Statute 11-815, Part C, says that it's unlawful to erect, construct, reconstruct, maintain, or use any land in any zoning district in violation of any regulations or any provision of any ordinance pertaining to the land, and any violation constitutes a public nuisance.
Did the county avoid that statute? I mean, because I thought we were talking about 11321E and the zoning ordinance 1201.02. And to follow up, I don't see anything in 11321E or in the zoning ordinance that says anything about maintaining.
In section 1201.01, of the zoning ordinance, it states that it is unlawful to erect, construct, reconstruct, alter, or change the use of any building or other structure within a zoning district covered by the ordinance without
That
first
wasn't an
obtaining.
issue here, right? Weren't they seeking a permit for something unrelated to these buildings? They weren't seeking to reconstruct or alter those buildings.
In this case, they were certainly using that 500 square foot shed.
But they weren't reconstructing, and from what you just read, I'm not, and what was alleged in the complaint? What the allegation that they violated, I got from it, they were violating 120102. 120101 doesn't sound like it's applicable either, but what else was alleged in the complaint?
I believe the complaint was 1201.02.
And that says it is unlawful to perform any work without the required permits. So if you happen to own a structure that isn't permitted, if you're not doing any work, you haven't violated that ordinance, correct?
They were cited for that provision. First of all, before the complaint was filed, they were advised that you have a structure on your property that doesn't have the correct permits. And they were asked to take care of that. They were told, you requested permits to add bathrooms onto your main structure, and we're not going to pull those permits. We're going to continue to allow those permits to go on. And they finally got a certificate of occupancy for those additions. But they were told, you need to correct the violation, which is you're maintaining a structure without permits. They were then, they took no action. They were sent a letter.
But let's just move to the point where your client files a complaint.
Right.
The complaint alleges that you violated 120102.
Correct.
So that's what they're on notice for.
Isn't that what we're addressing? Did they violate 120102? Did the court get it right when they said, technically what we're addressing, did the court get it right when it said they didn't violate 1201.02? Is there anything else that's before us other than that ruling?
I believe the fact that they're maintaining a structure without the permits is before you.
And how is it before us?
Because at the hearing, their defense was, well, we didn't put it there.
Do they need a defense to the allegation in the complaint is a violation of this particular statute? Where is the violation of that statute? Are you acknowledging now that they're not in violation of that? You're just suggesting they're violating a different statute, or?
I think if this had been filed in a justice court as a Class 2 misdemeanor, maybe that's a good argument. This was not, the county didn't proceed with a misdemeanor complaint. They proceeded as a civil matter only.
So in a civil matter, you don't have to allege if you're alleging a violation of a statute in a civil matter, don't you have to allege the statute that you think they're violating?
It was my position, they understood what the violation was.
Well, they understood that somebody built the property without permits on there, but did they understand that they're in violation of a statute that says they can't stay on the property without getting a permit? Is there a statute that says that?
A statute that says that they have to
That they can't stay on, that they're violating a statute by living in a property where there was an unpermitted building.
The statute I read earlier says you cannot maintain a structure that's in violation of the...
And was that alleged in the complaint?
Not specifically, no.
Then doesn't that end the matter? I guess you can file a new complaint alleging a violation of that statute or that ordinance, but for the ordinance that was alleged in this complaint that's currently before us, they didn't violate it. Can we agree I mean, I understand that your position is that they've violated a statute or an ordinance, that you know, they're maintaining an unpermitted structure, but that's not what was before the trial court, that's not what's before us, correct?
Well, if the courts has the transcripts of what took place before the hearing officer and the Board of Supervisors.
Was the complaint amended to allege a different statute? Is there something that?
I think by the fact that the parties were arguing whether or not 321E.
But we're here to review the court's decision. Did the court decide anything other than that there was not a violation of 120102?
The court decided that, well, it's our position, the court decided that 11321E was a defense in this case.
But the allegation that was raised by your client was there's a violation of 1201. So even if they get that wrong, that it's not a defense, you still have to prove your case that there was a violation of 120102. If that was the only thing that was before the court.
I think if at the hearing that was an issue, then the complaint would have simply been amended. It was never raised as an issue. I think the complaint was amended that, no, you're maintaining a structure without the required permits.
Is that in the record?
I believe that that's clear from the transcript of what was occurring at the hearing, what occurred.
Well, but simply because they discussed it or argued it doesn't mean that the complaint's been amended, right?
Well, to the fact that we got to this point and now that's the argument, I think that would be unfair to the county. The county was just trying to ask them to get the permits for their structure, and the arguments that were being made were addressed to whether or not they were allowed to maintain the structure, hence the defense of 11321E.
But the arguments that are being made are in response to a lawsuit that's filed where there's an allegation that they're violating a zoning ordinance. Are they responsible for coming up with for suggesting that the complaint be amended to charge them with something, to allege something different? Why would they bear any responsibility for whether the complaint's amended or not? They're addressing a complaint that there was a violation of a particular zoning ordinance.
Well, I think the fact that the county didn't pursue this as a criminal matter but did pursue it in front of a hearing officer does change that quite a bit. That it's a little bit less informal. There is a provision in the zoning ordinance. It may not be exactly on point. No complaint shall be deemed insufficient for failure to contain a definite statement of the essential facts constituting the specific violation which the violator is alleged to have committed. If the complaint
I think everybody understands the facts, that there are some unpermitted buildings on the property, but that doesn't, I don't know that goes to whether what's been alleged, whether those undisputed facts establish a violation of the ordinance that's been alleged to have been violated.
Well, I believe everybody was clear that we were talking about maintaining a structure. Everybody was clear, and we don't know the facts, but it's undisputed. In other words, we're not disputing that the Valenzuelas did not place that structure there.
If it's undisputed, why wasn't the complaint drafted in a way that is consistent with what apparently was argued.
Well, it's true, nobody, the zoning inspector is not an attorney, obviously, did not make a motion to formally amend the complaint. But from the proceedings, I think it's pretty clear what was being alleged by the time we were having these hearings. In addition, okay, first of all, I said they were sent letters in July, September 2014, letting them know, hey, you have a structure in your property that's unpermitted. You need to get the permits. The complaint was filed in December 2014. We had a hearing in February 2015. That hearing was conducted. They were found in violation. The Valenzuelas hired an attorney and asked for a rehearing that was held in August of 2015 to use ARS 11321E as a defense. That's what they filed some motions. They made that argument. And the hearing officer ruled that 321E wasn't a defense. He found that not having permits was a related to the words are health and safety. So I'm not sure how the court could not find that the complaint was effectively amended to include maintaining a structure without the required permits. The case then went to an appeal before the Board of Supervisors. The only argument there was, again, 11321E. And through all that time, nobody's alleging that, wait a second, we didn't, our defense is we didn't put it there. We all understood they didn't put it there. It was that they were maintaining it. And that's a violation of the zoning ordinance and state statute.
But not the zoning ordinance that was alleged in the complaint.
I think that argument could have been made in February. It could have been made in August when they requested and were granted a rehearing.
But we now have a ruling from a superior court that we will uphold if it's correct for any reason. And if we can look at that, the court's ruling is that there was not a violation of the zoning ordinance that was alleged in the complaint. So why can't we look at that ordinance, look at the undisputed facts that they did not build on the property, they didn't do anything that seems to violate that statute. So how? Well,
The hearing in front of the Superior Court was not a de novo trial on the matter, where we're prosecuting and defending the original complaint. It was supposed to be a review of the hearing officer hearing, whether or not he had facts sufficient to find that they had violated the zoning ordinance, and he did. Now you're saying, wait a second, it has to be this particular narrow subsection.
Well, we can't just have hearings where the county company says that these people violated some ordinances, and we'll develop that here at the hearing. They've got to say, here is the ordinance, or here are the set of zoning ordinances that are violated. How is, how, this isn't how we conduct hearings here. It doesn't seem to me.
Well, I think that with the record we have in this case, there's no doubt that everybody understood what the violation was and what they were found in violation of.
Except the drafter of the complaint, it seems.
Well, I I think it's not going to be unusual that somebody is cited for 1201.02 when there's destruction of their property, and they come into the hearing and say, well, I didn't put it there. And then the question is, do you amend the complaint, or if everybody agrees, do you have to file a new complaint? I could see those arguments. What's different about this is everybody understood what the violation was, going back to when they pulled the permits.
Why isn't there a ruling from the court that there was a violation of, or a hearing officer or someone saying this is the statute that you violated? Why isn't it the plaintiff's responsibility to, if the evidence doesn't conform with what was initially alleged, why doesn't the plaintiff have the obligation to amend the complaint? If you just end up with a ruling that says, no, there was not a violation of this statute, we're kind of hard-pressed to come up with a way to say that we can just look for any other statute that might have been violated and reverse what the Superior Court did.
Well, what the Superior Court did was not look at what the hearing officer did. The hearing officer did find a violation for maintaining, and that's what was being appealed. Thank you.
Thank you, counsel. Mr. Olson.
Good morning. Barry Olson. I represent the appellees in this case, Mr. and Mrs. Valenzuela. From listening to the panel's questions and comments relative to Mr. Fahili's arguments, I would open up with, if the panel has any questions of myself, it seems like the panel has a real good grasp as to the arguments of the Valenzuelas as set forth in our response brief.
Was there any kind of discussion about amending the complaint?
Never.
And you argue below, hey, what's alleged in the complaint is not what the county is claiming.
Well, correct. Basically, where this started off is that there was the complaint, as you've noted, that says you violated this ordinance. And all along we've stated is we're not in violation of the ordinance. And furthermore, I did raise the 11321E argument. And I'll be blunt with the court. I know why the county appealed this. We've been having this fight in Yuma County for years as to whether or not the county can cite subsequent owners for buildings that were previously constructed. And I've been practicing this type of law for a number of years, and we've been battling it out. Well, as we progress through the process, the issue is raised. You got to remember how this goes. You go to a hearing officer, not a lawyer, not a judge. It's a real different procedure relative to how due process works. You go to the Board of Supervisors. I don't know if you've reviewed that transcript. Again, you're before a political board, but when you got to the Superior Court, I focused on this argument. It's how could we be in violation of this? We didn't do anything that would be considered unlawful. And
is there anything that would keep the county from coming in and making an allegation under a different statute? Presumably, if our view of the statute is they clearly have not violated this statute. If they violated a different statute, if they come in and allege that, in your view, does this case somehow preclude them from doing that?
I don't know that it does. I think this case is limited to what they were charged with.
So if there is an ordinance or a statute that somehow that dictates that you can't continue to reside in an unpermitted structure, there would be nothing that would keep the county from pursuing that, if there is such an ordinance or statute.
Correct.
Anything else, Mr. Olson?
No, thank you.
All right. Thank you, counsel. All right, then. Thank you for your briefs and presentation here today, counsel. We will take the matter under advisement. We will issue a written ruling in due course. We will stand at recess at time, and we will stay at the bench and allow the parties from the next case to. Are the parties for the next case here? I know we're starting a little early. Yes? Okay. Then we will stand at recess, allow the parties to set up, and then we'll go once everyone's signed in and we're ready to go. Thank you.